This would have been a policy, whether you remember it now or not, that applied to you as a prosecutor.
I don't know whether this is a prosecution policy.
You can deny remembering it, you can deny reading it, but you can't deny something applying to you if it was post office policy.
So you're dropping your voice there. I couldn't hear you.
I don't remember it now.
Let's have a look at it anyway to see whether any of it jogs your memory. Did they include schedules of unused material?
Yes, yes, they should do. I would hope so, yes.
Hope is...
Well, they should be, yes.
A great thing. I'm asking you whether they did.
I didn't do the training, but I thought it's a must, isn't it? Yes.
But never mind whether you did the training, you were receiving these things for 17 years, because the Code for Crown Prosecutors is written for Crown Prosecutors, and it's written at a level and aimed at an audience that is broad and diverse, because it involves shoplifting in Newcastle and murder in Bodmin.
So we're jumping back into Jarnail Singh's testimony here, and it seems like, from what he's saying, his case has relied on hope. He hoped he received the disclosure documents, and he finds it a little bit amusing again. But he's saying, oh, well, it should have done, I hoped it would have done, but it's so long ago, I'm really struggling to remember now. So let's see how he explains it in this interesting line of questioning from Jason Beer KC as we jump back into the inquiry.
Can we move on, please, to poll 0010 4747? This is a casework management policy, and if we look at the foot of the page, please. Sorry, that's it. That's unfortunate, it doesn't include the date. If we can just go to the end of the document, please.
They needed Graham Ward here in his dating of policies. Clearly, the criminal law team needed to second him for some of that, because he was the one who made documents look pretty and correct, wasn't he?
Scroll up. Thank you. You can see that this is effective from March 2000 with a review date of January 2001. Okay?
Okay.
And if we go back to page 1, please, we can see the aim of the policy, its purpose, is described to be to ensure that adequate controls are in place to maintain standards throughout investigation processes. Would this have been a document with which you were familiar back in March 2000?
Too long
onwards.
It's just too long ago. I mean, I probably read it at some stage, but I can't tell you one way or the other where it landed or what we did or didn't do with it.
Can we go forward to page 4, please, and scroll down, please? I'm so sorry. If we scroll up, please, add a bit more, and a bit more, and a little bit more. I'm looking for paragraph 3.2, please. Thank you. Prosecution casework. This would have been a policy, whether you remember it now or not, that applied to you as a prosecutor from March 2000 onwards. Agreed?
I don't know whether this is a prosecution policy, because I think
It's literally got prosecution written in it and how you handle prosecution casework. So presumably the audience isn't like non-prosecutors. That wouldn't make any sense. I mean, you can't deny what applies to you. You can deny remembering it, you can deny reading it, but you can't deny something applying to you if it was post office policy.
I relied on most of the time was the prosecutor's code.
By that, do you mean the Code for Crown Prosecutors?
Yeah.
The CPS document?
Yeah.
What about any internal post office policies?
Well, I think prominence was the prosecutor's code. I don't know the other side of it, to be honest. I mean, it's such a long time ago as to I padded out or I had any influence or input into it, but that was the one we concentrate on.
So you're dropping your voice there. I couldn't hear you.
So it dried up.
If you just take a drink, thank you. So this isn't something that you now remember as something that you worked to when you were conducting prosecutions from March 2000 onwards?
I don't remember it now. It's just...
Let's have a look at it anyway to see whether any of it jogs your memory. It says details of evidential requirements and casework preparation and submission timescales are set out in the prosecution guidelines issued to all investigators to maintain standards and ensure consistency. Official forms should always be used in preference to locally produced forms. And then scroll down, looking at the 4th bullet point, enclosure envelope should be used to enclose the following supporting documents: Appendix A, Appendix B and C, and you can see the list of documents that should be enclosed, I think, when a file was sent to legal services. Does that list of documents remind you of the type of documents that you got when a file was sent to legal services?
Well, at that time, maybe there's more or less, but that seemed the standard, isn't it? Everything's there: the search, the friend form, disclosure forms, confidential.
Well, there could be more, but surely not less, because surely one of your jobs was to check that that was all there before launching the prosecution.
Report, copy of a tape recorded interview, that type of thing, yes.
So the reason for asking, can I make it plain, Mr. Singh, is that the inquiry is interested in the nature and extent of the material that a lawyer got to see at the point on deciding evidential sufficiency and public interest. And I'm asking you, is that a list of the things that a lawyer would see when they made an evidential sufficiency decision and a public interest decision?
I would have thought that would be the basic. Maybe later on there were more added onto it. I don't know, but certainly that seems, more or less every investigation file would have or should have.
So it included at least this, but maybe more.
I would have assumed so. Yes. I mean, to be honest, I've been out of practice on the post office side of it for such a long time. And especially the date of the document, I don't know whether they modified it. There's more to it. I don't know.
When you got files, importantly, did they include schedules of unused material?
Yes, yes, they should do. I would hope so. Yes.
Hope is,
well, they should be. Yes.
A great thing. I'm asking you whether they did.
Yeah. Well, yes.
And so you would be able, when you're advising on evidential sufficiency and public interest, to see what unused material there was, at least by list.
They should. I think if you look at the, I didn't do the training, but I thought it's a must, isn't it? Yes.
But never mind whether you did the training. You were receiving these things for 17 years.
Yes, I suppose yes, but I don't recall it now as to each and every single file had it. I don't know that, but that looks like it should be in the file. Yes.
Yeah, well, that's something that you should be checking, surely. And the question isn't really whether you remember each individual file, but more that you remember that you would have received a list of undisclosed evidence, because that's one of the core issues here at the inquiry relating to disclosure or lack thereof from the post office.
Which documents did you have regard to when making a decision on evidential sufficiency?
Well, all of them. Disclosure forms, confidential report, interview, tape recorded interview, investigators report. I mean, they're all relevant, aren't they? They search records, friend forms. They should all be there, shouldn't they? Because if they're not, then how can you advise without them? And
so you wouldn't just read the investigation reports, you would read the underlying material, is that right?
I think so. Yes. Yeah.
And never mind the documents that you should receive, thinking about the approach that you should take or the test that you applied. You've told us, I think, that you had regard to the Code for Crown Prosecutors.
Yes.
Was there any Post Office Limited document that helped you on how to apply that test in the context of a private prosecution?
I don't know. I don't know. Unless it was with the inquiry papers, I don't know.
So basically, unless you have evidence that it existed, I'm not sure.
Because the Code for Crown Prosecutors is written for Crown Prosecutors, and it's written at a level and aimed at an audience that is broad and diverse, because it involves shoplifting in Newcastle and murder in Bodmin.
Yes.
Was there anything that applied that to private prosecutors in the context of the Post Office, carrying it into effect in your business?
Well, that's the way I was trained. That was the way the other lawyers I worked with, and we adopted the same. I mean, the evidential test, the public interest test, and the disclosure, and alternative way of dealing with it in view of the public interest test. That's what we applied. I don't know what more you're asking me about. I don't know any more than that.
Well, essentially, he's asking you, was there any official policy to take this very broad policy, which sounds like it could be largely inapplicable to you, the Crown Prosecutor's Code, and apply it to the actual business that you were doing your job in? I mean, it seems fairly simple, really.
Can you recall any case in which you concluded that there was sufficient evidence to prosecute to provide a realistic prospect of conviction, i.e. meeting Limb 1 of the full code test, but nonetheless you decided that prosecution wasn't in the public interest under the second limb?
I think so. I think few. I think in probably few. I mean, I can't give you the names, but I think I did.
Can you remember? Sorry, this document can come down so the chairman can see. What was the context, even if you can't remember the names? Full code Lim 1 met, but it's not in the public interest to prosecute.
Well, there was I think there's a figure of 5,000 somewhere. Health.
Sorry, just taking them in turn. There was the figure of some 5,000.
I think it's 5,000. I think they, for the back of my mind, if there's less than 5,000 or around about 5,000 was the figure. It's not in public interest of the post office.
And when did that criterion apply?
I can't say whether it's always been there, but I can't tell you the precise date. Certainly the health of the
hold on. So on that one, the alleged loss was less than 5,000 pounds.
I think it's about that. I think it was about 5,000 around about that time. I can't tell you as and when, but that figure for some reason comes to mind.
Okay, and so health, that's the health of the defendant.
The health of the defendant, his family, the circumstances, the period of offending, was it one-off offence, I think part of it was whether they repaid the money back, and also I think the cost of prosecution in light of the overall, the overall case.
Thank you.
There's about 5 or 6 of them, I think.
Well, the cost of prosecution is surely whether it's in the post office's interest. But I guess if they're handling public money, you can argue there's a public interest there, so fair enough.
In your time, in the 17 years before separation?
I think what I did have a template. I had a habit of actually, on the side of it, the public interest test, about 6 or 7 different bits I used to look at, and sometimes even go around chatting to people and saying, look, this is what I got. It's sort of marginal. What do you think? What else should I need to do to either prosecute or not?
But that was literally your job to decide whether to do it. I mean, fair enough, consulting other lawyers, maybe. Cartwright King, I'm surprised he's not mentioned them, although we are talking much earlier on prior to their involvement, so maybe that's why. But, consulting the cleaner or consulting an administrator wouldn't necessarily help you with that. It sounds almost like we're trying to push a bit of responsibility away again from us and say, actually, will other people help me make this decision?
That sort of thing, yeah. There was various aspects. I mean, I'm sure there was a number of cases, but certainly there has been where we're not prosecuted because of the public interest test.
Thank you.